Judicial Independence Podcast. Podcast on the challenges to the independence of the judiciary, access to justice, and the protection of human rights across the European Union. Welcome to this podcast mini-series on the judicial independence in the EU. This podcast is part of the Rule of Law for Lawyers project, led by the International Commission of Jurists in partnership with Free Courts, Aditus, Forum for Human Rights and Human Rights in Practice, looking into the current challenges to the rule of law, especially to the independence of the judiciary in Europe. These challenges are numerous and in many cases extremely serious and can limit access to justice and have negative impacts on lives of millions of people across the EU. In the 10 episodes of this podcast, we will speak with experts and legal practitioners to shed light at some of these issues, and will discuss about ways to protect and preserve judicial independence so that human rights across the EU can be effectively protected. Hi everyone, I'm Karolína Babická from the International Commission of Jurists. Today we will speak about Bulgaria, which is an EU member state that has been over the years facing some challenges regarding the rule of law. A number of reforms took place in the past years in Bulgaria, also a constitutional reform, and last year the European Commission has closed finally the cooperation and verification mechanism with Bulgaria, meaning that Bulgaria has fulfilled all the benchmarks and recommendations under the mechanism. But there are still challenges persisting, and these are related to mainly political influence on the judiciary and the prosecution. There are gaps in the anti-corruption efforts and also pressures on media freedom. And we have here with us today an expert from Bulgaria, Adela Katchaounova, attorney at law and co-chair of the Legal Defense Program, director of the Bulgarian Helsinki Committee. So welcome, Adela.
Hello, Karolína. Nice to be here.
Thank you for your time. It's really great that you can be here with us today. So we will have now the opportunity to discuss some of the most recent issues that have raised concerns in Bulgaria among the legal community and also to some extent at the international level. So first of all, I wanted to ask you immediately about the constitutional amendments that were enacted a year ago, then were ultimately declared unconstitutional by the Constitutional Court in July 2024. What were the objectives of these amendments in the first place? And perhaps what implications does this ruling have for Bulgaria's ability to address some long-term challenges like the powers of the Prosecutor General or the politicization of the Supreme Judicial Council?
Yeah, that's a great question indeed. The constitutional amendments from December 2023 had one particular objective, even though they had also other issues to deal with, but the greater issue was the judicial reform. Our latest regular government, because I open bracket here, we're in the storm of 7 consecutive parliaments that are unable to appoint regular governments. So we are in the cycle of going on too many elections, like twice a year. So our latest regular government was formed a coalition with the goal to reform the constitution and to bring the judicial reform to an end, finally. Because in Bulgaria, this talk has been ongoing for the last 20 or even more years. But the judicial reform mainly stemmed from the duty of Bulgaria to execute one very important judgment of the European Court of Human Rights, namely Karolína v. Bulgaria. It is a judgment from 2009 dealing with very important issues like the position of the Prosecutor General in the Bulgarian judicial system, the separation of powers within the judicial system, and too many powers and the absolute lack of control over the prosecution office. So the judicial reform from last year actually finally opened up the constitution and brought amendments there, because the issue up until that moment was that no significant reform is possible unless we reform the constitution. And the constitutional amendments, I'll be short here, not to go all through them, but mainly they limited the years in power of the Prosecutor General. decreasing from 7 to 5 years. This was so seen like an important step for limiting the powers of the Prosecutor General. The amendments also divided the Judicial Council into two separate councils, the Judicial Councils and the Prosecution Council. There were also other amendments, namely in the powers of the Prosecutor General and limiting the powers of the Prosecution Office within the criminal justice system, because until that moment the Bulgarian Prosecution Office had a wide range of powers, including the so-called overall oversight of the judiciary or the judicial control over any issue in the country. So this was taken away by the amendments from last year. It was a step forward. Those amendments were awaited for a long time. Bulgaria was praised for them by many institutions, including the European Commission and the Venice Commission as well. They lasted only for like 6 or 7 months. They were enacted in late December, and early January it was the president and few political parties that introduced pleadings with the Constitutional Court to have them declared unconstitutional. The decision of the Constitutional Court came out in late July this year, 2024. And ultimately, the court declared the majority of those amendments unconstitutional. It was a huge blow for everybody. It was a very long Constitutional Court decision, but we can really distill from it one major point, which is that these amendments are not a job for the National Assembly. It should have been a Grand National Assembly to bring these amendments, because the Constitutional Court reasoned that the position of the Prosecutor General and the powers of the Prosecution Office as a whole is a matter of governing the country. It's a matter of governance. This was very strange because the Prosecution Office still stays within the judiciary. It's not the parliamentary idea of this country has not been changed in any way, and still the Constitutional Court decided in this matter.
Are there any further steps planned on this? Because indeed it seems like quite a pity after all these efforts that have been made to bring these amendments into place. And they were also really following a lot of the recommendations that Bulgaria had to follow. Do you know?
These amendments were up until that moment of the Constitutional Court decision in late July. The Bulgarian Parliament was trying to adopt other acts, the Judiciary Act most importantly, but this is still not the case. There was a very good draft elaborated, but this act has not been in discussions lately. The government lost power. We had elections in April and then in October this year, already twice. And the Judiciary Act is not even in the plans of the near future. So we are kind of in a limbo situation. The political platform for judicial reform is no longer possible. There are no parties that can actually claim power with the view to reform the judiciary anymore. This is seen as a topic that it's empty now. The general public really don't buy it anymore. So we really need to think of other ways to bring the Bulgarian judiciary in line with all the recommendations and in the end to see it as an independent and impartial power. So we see it more of an effort to have the magistrates to be independent. We really have a great deal of work there.
Yeah, that sounds really like a difficult situation. Thank you so much for explaining that so concisely to us. And perhaps another issue to discuss would be the situation of the Supreme Judicial Council that has been operating with expired terms of office for some time now. So what challenges does this specific situation bring, and what do you think maybe should be the next steps to be taken to restore the credibility of the institution?
Yeah, the current Supreme Judicial Council is in place for more than 7 years now, which is with 2.5 years above the time limit. It's still in operation. And in this time, it is the council that elected the former Prosecutor General. Then the former Prosecutor General stepped down from office, stripped him from powers, and now is on the verge to elect the next Prosecutor General. the general attitude, perception of the council is too low. There is no trust in its decisions. And what we really need is to have a functioning parliament that actually elects the next members of the judiciary, because the other powers are linked to these elections. But the parliaments with 7 or 8 parties cannot form any majority. So no parliament elects new members, not only to the Supreme Judicial Council, but to many other bodies in Bulgaria are working for years and years above their time limit now. This is a major issue for the democracy and the rule of law, of course, in the country. But with the Supreme Judicial Council, this is especially the case because we're afraid that it's going to step forward to elect the next Prosecutor General. This procedure is ongoing, and we are expecting already in mid-January 2025 to have this election. There is only one candidate for this position, which is the current caretaker Prosecutor General. His position also lacks trust in the society. He lacks credibility. He lacks his education and training are not credible enough. And he has been a deputy for the former Prosecutor General and the one before him. And after he took office in July 2023, some major corruption cases were stopped. Those major corruption cases concerned the former Prime Minister of the country. And it's what we were hoping to see to be brought to light is now that investigation, which is thanks to this current caretaker Prosecutor General. So there are many voices in the country that oppose this step of the Supreme Judicial Council currently, but I believe those are weak voices having in mind the overall situation and the political instability.
Thanks a lot for shedding light on this issue as well. And we'll actually stay a little bit still with the question of expired terms of office, because there was another important question about the president of the Supreme Administrative Court, where, if I'm correct, I believe the constitution is requiring a new election after a term of office expiring. But there was a recent decision to allow the acting president to remain in office. So how did this happen, and what do you think may be the consequences of this decision?
Yeah, you're absolutely right in presenting this question. The president of the Supreme Administrative Court was actually asked by the judges in the court to continue his mandate after this one expired. His mandate in office expired on the 22nd of November, just a few days ago. And still he was, on the one hand, asked by the majority of the judges in the court to continue his term of office, despite the very clear constitutional provision in that matter. Subsequently, this voting, the Supreme Judicial Council agreed with the position of the judges of the Supreme Administrative Court and allowed the president to continue his term of office indefinitely until a new procedure is opened and a new one is presented. And since there were no candidates, no one from him, no new procedure was opened. Then we have the promise that a new procedure will be opened, but no one actually from the administrative court judges are willing to step in and to go for this position, which is very particular and very peculiar at the same moment. Those are supreme judges that are actually acting against the constitution. And this brings the question, why is this president of the administrative court so important to keep in office? And since the major disciplinary court cases go through the Supreme Administrative Court and the appointment cases of many bodies go through this court, we believe it is securing a very convenient position, not only for this particular president, but also for many other institutions and bodies in the country. Of course, this is violating the rule of law.
Yeah.
And it brings very serious issues. Why is that Supreme Court judges actually willing to do that?
Yes, totally. That sounds quite concerning. Thanks so much for giving us a little bit more insight into this as well. Finally, and as discussed when we prepared also for this episode, it would be great if we could touch upon a landmark judgment of the European Court for Human Rights in Todorova versus Bulgaria. I think today one of the famous judgments, which highlighted some of the risks of political pressure in judicial proceedings and also contributed to the broader conversation about judicial independence. I mean, it would be great if you could also help our listeners to understand what were the main findings of the judgment and how or whether at all it has influenced the Bulgaria's judiciary approach to independence, or where we are actually also with the implementation up to date.
Yes, you're absolutely right. This is a landmark judgment of the European Court of Human Rights. And its major achievement is that it brought to light the undertones and the issues in the judiciary. Judge Todorova, I think we should really start with who she really is. In the time of the events was the president of the Union of Judges in Bulgaria. It is a non-governmental organization of the judges. And as in that capacity, she was quite vocal and active and opposing many appointments in the judiciary. She was bringing light to why this and that person was being appointed as president of a court or as a member of the Judicial Council. And for this, she received a reprimand. I'll put it in short, of course. She was disciplined in the end by the Judicial Council for speaking so much and so loudly. She was a frequent public speaker, very openly making statements before media. And she was disciplined finally with stepping down from office, which she managed to overturn in the court. But she was finally demoted for 2 years in a lower court. And a part of her remuneration was decreased as well. So she brought a case before the European Court of Human Rights, claiming violations of just judicial process, her personal rights, because her reputation and dignity suffered, her freedom of expression was violated, and in the end the court found violations of Article 10, because the court clearly found that her freedom of expression was violated because she received several disciplinary measures because of her open remarks made before media. But these disciplinary sanctions she received because the goal was ultimately to make her silent. This was seen as contradictory to any convention rights. And the court found a violation of Article 18 as well, which is actually very rare for the court. Bulgaria became the 6th country in the system of the Council of Europe to have an Article 18 violation. This judgment is now almost 3 years old, and we have to admit that we haven't seen a major shift in the Bulgarian judiciary following what I explained already. The judicial reform is not a success. It's not a success story, not at the moment. So judges and other magistrates can be made silent in Bulgaria, and we still need to work on the execution of judgments. The latest findings of the Committee of Ministers regarding the execution of this judgment was that this judgment can be executed only in relation to the other issues of the independence of the judiciary, namely the constitutional reform that was overturned, and in the Judiciary Act. This is still not the case. So we're having now one more judgment that Bulgaria needs to execute. Not really making great steps forward in this regard, as the political situation currently is so unstable that we cannot even bring this topic to light.
Okay, well, thanks so much for the really good overview of what the decision has been about, what the case is about. Indeed, this sounds like a very successful litigation. We were also looking into this in the ICJ over the past 2 years that we have been working on the Rule of Law for Lawyers project that was really focusing on strategically litigating judicial independence. across EU member states. But indeed, we also often see that, one thing is having a good decision, the other thing is its implementation, its execution, and it often lags behind, unfortunately. And we also see in other work that often one good decision is not enough for a systemic change, but, over time that may just actually help with a number of other litigation or other work towards the protection of the rule of law, and hopefully lead to the protection of the rule of law and judicial independence, especially in this case. So I really hope, that the fact that the implementation is so much lagging behind still, that it will improve. And it's already really great to hear that the case has been so successful, and it is indeed an important judgment.
It is an important judgment, but I believe that more judgments are to come, which is quite unfortunate for Bulgaria as a country, but also shows some excellent work of other judges and lawyers in that regard.
That's great, indeed. And that may be also the way to actually improve the system. There's more decisions that are all pointing to the same direction that may hopefully over time really lead to some of the systemic changes that are still clearly needed. Okay, but thank you so much for your time and for talking with us today. It was really a pleasure to have you, and all the best with your work.
Thank you, Karolína. The same. Wish you all the best with your work. Great talking to you.
Same.
Thank you for listening to the Judicial Independence Podcast.